Welcome back to Protecting Trade Secrets. I'm Professor Seth C. Oranburg. In the previous two lectures, we covered employee confidentiality agreements and the joiner-mover-leaver protocol, the structural and procedural foundations of internal trade secret protection. We learned how to draft enforceable contracts, manage employee transitions, and document the processes that courts expect to see. But contracts and protocols are only as good as the people who execute them. Policies on paper don't equal reasonable efforts. Courts don't just ask what your policies say, they ask whether your organization actually lived them. Did employees know what was confidential? Did they receive ongoing training? Were violations addressed consistently? Or was confidentiality just rhetoric, something claimed in litigation but ignored in daily operations? This final lecture of Module 4 addresses the human side of trade secret protection: training, culture, and enforcement. We'll explore why training matters legally, what effective training looks like, how to document it, and how to build a culture where confidentiality is embedded in everyday work, not just asserted when things go wrong. We'll also examine the critical role of enforcement, why consistency matters, what happens when companies make exceptions for high performers, and how selective enforcement destroys credibility in court. By the end, you'll understand that trade secret protection isn't just a legal compliance exercise. It's a cultural discipline, one that requires leadership modeling, continuous education, and the willingness to enforce consequences when obligations are breached. Let's start with why training matters in the eyes of the law. Courts evaluating trade secret claims don't just look at whether a company had policies. They ask whether employees knew about those policies, understood them, and were reminded of them over time. This expectation flows directly from the reasonable efforts standard. If a company claims that information was a trade secret, but employees didn't know what that meant or how to protect it, courts will question whether the company genuinely treated secrecy as a priority. Training is the bridge between written policy and actual behavior. It's how companies demonstrate that confidentiality wasn't just an aspiration, it was operationalized. The legal significance of training appears repeatedly in case law. In Data General Corporation versus Digital Computer Controls, a 1975 Delaware Chancery case, the court found that Data General had built a strong culture of confidentiality by using access controls, training, and internal policies to ensure its employees understood their obligations. The court emphasized that the company didn't just write rules, it embedded them in practice through consistent education and reinforcement. That credibility tipped the balance in favor of legal protection. Contrast that with Failsafe, LLC versus A.O. Smith Corp., a 2012 Seventh Circuit case. Failsafe developed a pool safety technology and shared it with a prospective partner without using confidentiality agreements, markings, or internal secrecy practices. The court found that Failsafe had failed to treat the information as secret in any meaningful way. There was no training, no internal documentation, no consistent enforcement. As a result, the court held that the information did not qualify as a trade secret. The difference between these cases isn't the quality of the information, it's the quality of the system. Data General trained its people. Failsafe did not, and courts responded accordingly. Training matters because it creates notice. Employees can't comply with expectations they don't understand. When a company provides clear, role-specific guidance on what qualifies as confidential and how to handle it, employees are far more likely to act appropriately. When that guidance is absent, even well-meaning employees make mistakes, forwarding emails they shouldn't, reusing templates that contain proprietary content, or discussing projects in public settings without realizing the sensitivity. Training also creates evidence. When trade secret litigation arises, the company will need to prove that it took reasonable efforts. Training records, sign-in sheets, completion certificates, quiz results, documented sessions are some of the most persuasive forms of evidence. They show that the company didn't just assume employees knew what to do, it verified that knowledge and documented the process. Finally, training creates accountability. When employees receive explicit instruction on trade secret obligations, they can no longer claim ignorance. If a violation occurs, the company can point to the training and say, "You were told, you acknowledged, you violated anyway." That clarity strengthens both internal discipline and external enforcement. Not all training is created equal. Courts distinguish between perfunctory compliance exercises and genuine education. The difference lies in specificity, relevance, and follow through. Effective training is role specific. A software engineer needs different guidance than a sales representative. Engineers work with source code, architecture diagrams, and proprietary algorithms. Sales reps work with customer lists, pricing models, and strategic account plans. Generic training that says, don't share confidential information, without explaining what is confidential in the employee's actual role is insufficient. The best training uses concrete examples drawn from the employee's daily work. Instead of abstract definitions, it walks through scenarios. If you're sending a pitch deck to a potential client, here's how to mark it as confidential. If you're collaborating with a vendor, here's what you can share and what you can't. If you receive an email asking for competitive intelligence, here's what to do. Scenarios make the training actionable. They move from theory to practice, and they give employees decision-making frameworks they can apply when supervisors aren't around. Training should also be interactive, not passive. Watching a video and clicking "I agree" at the end doesn't create comprehension. Testing does. Many companies include short quizzes or decision trees at the end of training modules to verify that employees understood the material. These assessments don't need to be complex. They just need to demonstrate engagement. Interactive training also provides an opportunity for questions. Employees who don't understand a policy are unlikely to follow it correctly. Creating space for clarification, whether through live Q&A, follow-up emails, or discussion forums, reduces the risk of well-intentioned mistakes. Frequency is another critical factor. Training can't be a one-time event at onboarding. Courts expect ongoing reinforcement, especially in industries where information handling practices evolve or where employees regularly work with new projects and partners. At a minimum, companies should provide annual refresher training. But certain events should trigger additional sessions. When a new high-value project begins, when a competitor hires away employees, when a data breach occurs in the industry, or when new collaboration tools are adopted. These moments create heightened risk, and training helps employees navigate them. Ongoing training also signals to courts that confidentiality was a sustained priority, not just a box check during onboarding. When a company can show that it reminded employees of their obligations regularly, judges are more likely to believe that secrecy was embedded in the organization's operations. Documentation is essential. Every training session should produce a record: who attended, what materials were covered, what acknowledgments were signed, and what assessments were completed. These records aren't just for HR files, they're litigation evidence. If an employee later violates their obligations and claims they didn't know the information was confidential, the company can produce the training record showing they were explicitly told. If the company is sued and must prove reasonable efforts, those records demonstrate a systematic approach to education. Some organizations use learning management systems to automate documentation. Others rely on sign-in sheets and certificates of completion. The format matters less than the fact that it exists and can be retrieved when needed. Training creates knowledge, but culture creates behavior. Even the best training program will fail if the organization's culture doesn't support it. A culture of confidentiality is one where employees understand that secrecy isn't just a legal requirement, it's part of how the organization operates. It's embedded in daily workflows, modeled by leadership, and reinforced through incentives and consequences. Culture starts at the top. If executives treat confidentiality casually, discussing sensitive projects in open spaces, forwarding documents without checking distribution lists, or making exceptions for themselves, employees notice. And they adjust their behavior accordingly. Courts have cited this kind of leadership failure as evidence that a company's confidentiality claims were performative rather than real. By contrast, when leaders model good behavior, locking their screens, marking documents as confidential, asking before sharing information with third parties, employees see that the rules apply to everyone. Leadership modeling is one of the most powerful forms of cultural reinforcement. Culture also depends on transparency about why secrecy matters. Employees are far more likely to comply with policies when they understand the stakes. If they know that a particular customer list took years to build and represents the company's primary competitive advantage, they'll treat it more carefully than if they're simply told, "This is confidential." Some companies integrate confidentiality into performance reviews. Managers evaluate not just whether employees met their targets, but whether they handled information appropriately. Did they follow access protocols? Did they report concerns when they saw potential violations? Did they ask questions when they were unsure? This kind of accountability doesn't require punitive measures. It just requires acknowledgement that confidentiality is part of the job, not separate from it. Culture also involves incentive alignment. If employees are rewarded primarily for speed and results, they may cut corners on security. If confidentiality is treated as someone else's problem, something legal or IT worries about, employees won't prioritize it. But when companies recognize employees who report security concerns, when they celebrate teams that design secure workflows, and when they make confidentiality part of what it means to succeed at the organization, behavior shifts. Finally, culture requires open communication. Employees need to know whom to contact if they suspect a breach, if they're unsure whether something is confidential, or if they see a colleague mishandling information. Without clear reporting channels, well-meaning employees stay silent, and small problems become large ones. Companies with strong confidentiality cultures make it easy to ask questions and report concerns. They don't punish employees for raising issues. They treat those reports as valuable signals that the system is working, not as failures. Policies and culture create expectations, but enforcement is what makes those expectations real. Courts repeatedly emphasize that trade secret protection depends not just on having rules, but on applying them consistently. When companies enforce confidentiality policies selectively, punishing some violations but ignoring others, they undermine their entire claim that secrecy was a genuine priority. Let me give you a concrete example. In Allstate Insurance Company versus Fougere, a 2021 District of Massachusetts case, Allstate sued a former agent for misappropriating customer information and training materials. Allstate had policies on paper, documents labeled confidential, non-disclosure agreements signed at hire, guidelines for information handling, but enforcement was inconsistent. Some employees followed the rules, others didn't. Violations were sometimes addressed, sometimes ignored. The result? The court found that Allstate's trade secret claims were weakened by its own behavior. If the company itself was unclear and inconsistent about what was confidential, how could third parties be expected to understand the boundaries? This case illustrates a fundamental principle. Enforcement must be consistent. Courts ask not just whether a company had policies, but whether it followed them. Did it respond when employees violated confidentiality obligations? Did it revoke access when protocols were breached? Did it enforce agreements even when doing so was inconvenient? Selective enforcement is particularly dangerous when it involves high performers or senior executives. Many companies hesitate to discipline top salespeople or influential leaders, even when they've clearly violated confidentiality rules. The rationale is pragmatic. We can't afford to lose this person, and enforcing the policy would hurt the business. But courts see it differently. When a company makes exceptions for certain employees, it signals that the policy wasn't really mandatory, it was aspirational. And if the policy wasn't mandatory, the information it was meant to protect may not have been treated as truly confidential. Consistency doesn't mean severity, it means predictability. Violations should be addressed through progressive discipline, warnings, retraining, restricted access, and, if necessary, termination. What matters is that similar violations receive similar responses, regardless of who committed them. Documenting enforcement actions is just as important as documenting training. When a violation occurs, the company should create a record. What happened, how it was discovered, what response was taken, and what remediation was implemented. If the employee was retrained, that should be documented. If access was revoked, that should be logged. If the employee was terminated, the reasons should be stated clearly in separation documents. This documentation serves two purposes. Internally, it creates accountability and consistency. Managers can't make ad hoc decisions if there's a record of how similar situations were handled. Externally, it provides evidence that the company took violations seriously and responded proportionately. Enforcement also extends to responding to external threats. If a company learns that a departing employee took files to a competitor or that a vendor disclosed information in violation of an NDA, it must act. Delay or inaction signals that the company didn't truly value the information. That response might involve a cease and desist letter, a lawsuit, or a request for injunctive relief. But it must be timely. Courts have denied relief in cases where companies waited months or years to respond, reasoning that if the information were truly critical, the company would have acted immediately. Sometimes a single violation reveals broader problems. An employee forwards a confidential document, not because they were malicious, but because they didn't realize it was sensitive. That suggests a training gap. An engineer shares source code with a contractor who hasn't signed an NDA, suggesting that onboarding protocols weren't followed. When these patterns emerge, the company should treat them as opportunities for correction. The violation should be addressed, but the system should also be updated. If employees consistently misunderstand what's confidential, the training needs to improve. If contractors routinely gain access without signing non-disclosure agreements, the onboarding process needs tightening. Courts give weight to companies that learn from failures. They're less forgiving when the same mistakes repeat, because repetition suggests that the company isn't serious about improvement. In rare cases, enforcement reveals that a policy was unworkable. Perhaps access restrictions were so cumbersome that employees routinely bypassed them to get work done. Perhaps labeling requirements were so vague that no one knew what needed to be marked. When that happens, the company should revise the policy and document why the change was made. This kind of adaptability doesn't weaken the company's legal position. It strengthens it. Courts understand that businesses evolve, that technologies change, and that policies must keep pace. What they don't tolerate is stagnation, companies that recognize problems but do nothing. Let's recap. Training matters legally because courts expect companies to educate employees about confidentiality obligations. One-time onboarding isn't enough. Ongoing training, role-specific content, interactive scenarios, and documented completion create the evidence courts look for. Effective training is concrete, relevant, and frequent. It uses real examples from employees' daily work, tests comprehension, and adapts to new risks and tools. Culture transforms training into behavior. When leadership models confidentiality, when incentives align with security, when transparency about stakes is clear, and when reporting channels are open, employees treat secrecy as part of their job, not an obstacle to it. Enforcement makes culture credible. Consistent application of policies, progressive discipline for violations, documentation of responses, and timely action against external threats all demonstrate that trade secret protection was real, not rhetorical. Selective enforcement, especially exceptions for high performers, destroys credibility. Courts ask whether the company followed its own rules. If it didn't, they'll question whether the rules ever mattered. This concludes Module 4. We've covered the full arc of internal risk mitigation, enforceable agreements, structured lifecycle protocols, and the cultural systems that make protection operational. In the next module, we'll turn outward to the external vulnerabilities that arise when trade secrets are shared with vendors, partners, customers, and collaborators. We'll explore how to structure those relationships, what contractual safeguards are essential, and how to preserve secrecy when control is distributed. Thanks for listening. See you in the next lecture.